Lovely. Well, welcome to the most exciting session of the event, the legal session. And we all love lawyers, don't we? And this one is about how to manage .co.uk your domain name disputes. I'm Jim Davies. Some of you will already know who I am. I have a long history of UK domain name disputes, but I started life as a lawyer working for Champagne in a Court of Appeal case, the Elderflower Champagne case. And as Helmut's mentioned earlier, I'm a former non-executive director of Nominet. I'm not going to say anything else about Nominet in this talk other than their role in the DRS. And I'm also company secretary of Open UK, the open source not-for-profit body. So we'll start with a question for the audience to make sure everyone is still awake after lunch. How do you avoid ever getting into a domain name dispute? What can you do to make sure you never get into a domain name dispute? Do we have an answer? A suggestion? Exactly. That is exactly the right answer. Thank you, Michael Toth. Because you can't otherwise. Because some complainants are frankly just barking mad and will raise complaints about anything and nothing. I'm not looking at you, Luca. You only ever bring very sensible complaints. But there are others out there who will just complain and try and grab a domain when they shouldn't. And if you have domains, it is always a risk that you may be on the receiving end of a UDRP for a .com, a DRS for a .uk, and so on. And here are some examples of barking mad complaints that I've dealt with in the last year. Now I chose mad, so amongst you, you'll see the top name there is last.co.uk by the rights to the famous television and novel appearing in novels Dog, but was in fact brought by someone who hadn't even started his business yet, however couldn't conceive that he shouldn't be entitled to Lassie, which for those from north of the border means a young lady in Scotland, as a famous dog. And needless to say, his complaint was misconceived, but required the client to proper defence, and as with three cases, ultimately resulted in a reverse domain tracking decision. But you would say that's a completely innocent domain, yet it had to be dealt with through the DRS process. Likewise, EW. Ew! Who could bring a complaint about that? Well, a very interesting character brought a complaint about that, as one or two in the audience who are on their phones would realise if they were paying attention. Andrew. Uh, yes. EW.UK. Ring any bells? That complainant not only claimed that he was entitled to a two-letter acronym, but he'd gone to the trouble of registering another version of EW with another domain extension first. He had registered a company called EW Limited or words something like that, and had tried to fabricate an entire narrative that on the face of it, if it hadn't been answered properly in a DRS, might have resulted in a decision, a summary decision in his favor. However, when he was met with a robust defense, he then decided to attack Nominet, saying that the domain complaint should be stopped and withdrawn. And when he realized that that couldn't happen under the policy, he then threatened them with a complaint to the Information Commissioner's Office for putting his name on a public document, notwithstanding that the rules make it very clear that you will be identified if you bring a complaint. So again, barking mad complainant. Nothing you can do as a respondent other than deal with it if you have a complaint filed. The one thing you mustn't do if you get a complaint filed, and we're going to the third case here, manage.co.uk, and you might well say, how could anyone sensibly bring a complaint against a generic word like that? Well, the problem here was the complainant, the respondent was unwell at the time of the receipt of the complaint, didn't respond to it, and in her infinite wisdom, Dawn Osborne, a very pro-complainant lawyer in my opinion, expert in my opinion, found in favour of the complainant in a summary decision. Only then was the complaint brought to the attention of the owner of the domain. He had to file an appeal. That includes a fee of £3,000 plus VAT. The outcome, of course, was that the American, there are no Americans in the audience, so I can say what I like, can't I? The typically aggressive American lawyer acting for the complainant doubled down and accused the respondent of actually running an illegal, like criminal, email phishing scheme with no evidence to support it at all. The outcome was that the complaint, the original decision was not only reversed, but reverse domain name hijacking was granted, which is very unusual on a reversing of an appeal decision. And the panel said that if they were that the complainant basically should be embarrassed by their conduct, and if they were able to award costs, they would. They said that in the decision, and they also said that the complainant should consider apologising to the respondent, a very respectable retired chartered surveyor who was baffled by all of the technical things that he was alleged to have done because he didn't have a clue what they were. Now, in contrast to that, we have the Greggs case. Now, for non-British people, Greggs is a very well-known bakery company, and they're famous for their sausage rolls. In the interest of diversity, that's actually the vegetarian sausage roll that I've got a photograph of. And Greggs also brought a complaint, one might say with slightly more merit perhaps than the Manage case. Manage was brought by this American multinational who I manage, who provides software to law firms. Greggs realized on receipt of the response that their complaint was misconceived. It was for Greggs with one G. They, as you can see there, used two Gs. And they agreed to withdraw their complaint, taking a different approach to I manage. So that's a very quick summary of some of the DRS cases from the last 12 months that have crossed my desk and are in some ways generically interesting. The Manage case in particular was of interest to the community at large because there was great concern that a generic term might be lost in that way in summary transfer for sort of policy thoughts. So the short answer, as Michael gave it earlier, is if you want to avoid a domain name dispute, the only way you can really do it ultimately is to have no domains at all. That's not really a practical solution. But the answer then is be alert so that you know that when a complaint is received, make sure that your email address with Nominet is up to date, because that was a problem with the Manage case, that if something arrives in the post that's a DRS complaint or a UDRP through the email, then make sure you respond to it promptly or instruct a lawyer, better still, instruct a lawyer, Luke, excellent Italian lawyer, or if you're desperate, myself. So that's a summary, a quick fly through of the last 12 months of the Nominet DRS and the .uk dispute process. Quite happy to take any questions from clients and fellow lawyers. Sorry. Oh, so the question was basically how much, when you receive a DRS or a UDRP, how much does it cost to engage a lawyer to defend it? Luca, over to you. Yeah, you could instruct a Ferrari like Luca and then pay accordingly, or a slightly battered old Ford Focus like me. Um, Personally, I offer clients fixed fee. Um, I look at very quickly summarize what the position is going to be. Obviously, some cases take longer than others. The managed case was actually quite time consuming because of the increasingly wild allegations that were being made. It involved creation of second level certificates, and whether that was sign of misuse by the client. In fact, the second level certificates had nothing to do with the client. And also the mail server had very great help there from Sado's legal department, who provided us with information to confirm that, because the domain was parked, that none of this activity was actually going on. But you're right, it is a cost of doing business. If a complaint is completely nonsensical, you could possibly do it yourself, but it's still a risk. You have to decide really on how valuable the domain is. A generic like manage is clearly a valuable asset. If it's a domain where you don't perceive a great deal of value, then I'd probably suggest, if it's clearly an unmeritorious complaint, looking to put something together yourself, perhaps. Sorry, I'm doing myself out of business there. Let me rephrase that. Not in the DRS or the UDRP. Well, except so. Well, as the managed panel said, if they were entitled to order costs, they would have done, because they were so outraged by the way the complaint had been handled. I don't think I've ever seen a panel say that before. An unusually fierce comment from the panel. But no, unfortunately, be careful what you wish for, because if you, as a successful, please don't all leave for that event in another part of the building. Yes, you'd say, yes, of course, in a case like this, the respondent should get his money back. But then think about all of the cases where you might end up as a registrant if you lose, if you open that door. And then if you're dealing with a Ferrari like Luca, then the cost for might be a lot more than you're paying your old British Ford Focus. Any other questions? Well, thank you very much for attending, and hopefully I'll be seeing all of you soon in a DRS, apart from you, Luca.